Okay, I'm going to spend a few minutes on a video here on chapter 2 and 3, and this is going to be kind of a very quick run through. So I'll also have a PowerPoint up, and it'll have a little bit of audio with it as well, just like last time. I did want to give you a brief video just because we want to try to recreate the classroom to some extent, at least as much as we can reasonably, but I don't want to bore you out of your mind either. So I'm not yet as sophisticated as I'd like to be in terms of integrating the PowerPoint into the video. I'm going to work on that, and maybe next time I'll actually have that all integrated, and then I can just do this in one fell swoop. We'll see. I'm going to give that a whirl. In the meantime, you'll get two. Briefly, chapter 2 and 3 that we're getting into now. Chapter, and you'll see me looking over to the side. I'm looking at my notes. Forgive me for that. For doing that, but I know it might be a little disconcerting sometimes, but just bear with me. How do you decide what tactics and strategies to employ? And we're talking about basically strategic orientation, the initial process. How do you know? Well, a couple of pointers. What's the other side's negotiating strategy? Now, you might say, well, how do I know? Well, you might not know. And if it's somebody you've never negotiated with, you have no idea, or you're a beginner, or you're new to the area, or you're new to the industry, you just might not have any idea, and this doesn't work. If you do have some experience, though, of course, you will know. For instance, if you've had prior negotiations with this lawyer or the other side, then you have some idea of what you can expect. People fall into general patterns and predictable sort of behaviors to some extent. I've never met anyone who's completely unpredictable. And so professionally, you're going to find that people are relatively stable. And as a result, you can count on them behaving similarly, but they may not behave exactly the same way every time. But it's some method for determining that. What else? Reputation. I mean, people do talk. If you're in a small community of lawyers or negotiators, there may very well be some discussions amongst you about how other attorneys do things or how other negotiators do things. And so you might be able to figure that out from asking, what's this guy like? What's this gal like? How do they react under these kinds of circumstances? I know an attorney, I won't even talk about where or when or any of those kind of details, but I do know of an attorney who had developed such a reputation for dishonesty that even some of the local courts required him to do certain things related to his scheduling of trials and scheduling of motions and so forth that they didn't require of other attorneys, simply because he just had proven himself untrustworthy even to the court. And you do not, for the lawyers out there, you don't want to be that guy or that gal. Because once you do that, it's just almost impossible to ever make up any ground. Make sure that you are the person who's known for being completely trustworthy and very credible. And if you're known that way by judges and by other lawyers, it'll take you a long way. They may think you're just an average lawyer, but if they trust you, they'll treat you a lot better than the guy or gal they think is a really spectacular lawyer who they can't trust. That's the reality of it. So keep that in mind. What are some other ways that you can figure out what the other side's negotiating strategy is? Well, are they cooperating? I mean, if they're cooperating initially, that kind of gives you a clue. And as an aside, what do you do if they're cooperating initially? Do you jump in and take advantage? Well, simple reality is you probably try to. If it's ethical for you to take advantage and it's going to benefit your client, you almost have to. And some of you may feel a little squeamish ethically about that, or morally. You may feel like, that's not right. They're trying to be cooperative. They're trying to help out. And here I am taking advantage. Particularly when you're representing someone else, you almost have to, because you don't have the luxury of just being nice. So if you're negotiating for yourself, do what you want. But when you have a client to protect, you kind of have to do what you have to do sometimes. Some specifics on how to decide what they're going to do. What are their initial tactics or their initial opening discussion? Sometimes that'll help you figure it out. Again, that depends on who you're dealing with. Some people are really good. They'll come in blustering like a hurricane and then back off. It's sort of like the football coach who knows that if he comes in and beats his guys up for the first 2 weeks of practice, when he pulls back a little bit later on, everybody loves him. But if you start off slow and you kind of pull back at the beginning and then you try to, crank down and crack down on people later, they don't like it. So the initial tactic may or may not give you a sense, but it's at least something to go on. What about prior negotiations? Well, again, that depends on whether you've been involved in negotiations with someone before. You can look at people who are situated similarly. Obviously, I have trouble saying similarly. Sometimes labor negotiators, insurance claims examiners. If you've had experience with one insurance claims examiner, maybe that helps you figure out what other insurance claims examiners are going to do to some extent. Again, it's not perfect, but it does give you some ideas. So these are things you can think about when you're thinking, how do I know what to do based on what they're doing? Excuse me. Probably the best way is for you to simply think, well, what would I do if I were in their shoes? How would I handle things? What kind of tactics and strategies would I use? That would probably be the best thing you can do in terms of figuring it out. How would I behave? The union story in the book on page 35 and 36, and by the way, when I say book, I'm referring to Gifford only. Getting to Yes, which I've told you can use and buy if you want. You can get it cheap. I'd probably get it for a couple bucks on Amazon. It's a good book, but it's not required. So get it if you will. But I will never refer to it. So when I refer to the book, I'm only referring to Gifford, which I have figured out since it is not Griffin, but Gifford. Gifford, the book, the story of the union negotiation is interesting because here you have a company that makes a really generous and decent offer that the union would have otherwise accepted, but problematically the company hadn't thought it through and realized we got to make these guys look good. And I can't tell you how many times I dealt with attorneys who I was, having a negotiation and a back and forth about a case, and the attorney would say, "Look, Gus, can't you give me another grand? Another $2,000 or $3,000 or whatever, maybe $5,000, depending on the kind of case and how big it was. It'll make me look like a hero. My client will love me, and it'll get it resolved now, immediately." So I might go back and tell my claims examiner, hey, look, I need a little bit more money because it's really going to work things out really rapidly and effectively, and we'll get this case put to bed. And sometimes it worked, sometimes it didn't. But if you know kind of what you're dealing with in advance, and the moral of that story is, maybe it's okay to make the other side look good if you get a good result anyway, and if you kind of get the result you're looking for. The company in that story should have started off a lot lower and let the union guys negotiate them up to where they wanted to be. I've even had conversations with people, and I remember one attorney who I told him, I said, look, I'm going to get you where you want to be, and I actually had to basically tell him, look, here's the 10 steps we're going to need. I can get you where you want to be, but I have to literally document that I took you through these steps in order to get you the money that you want in this case. He said, you got to be kidding me. I told him no. And I literally laid out for him. I said, you're going to say 70,000, and I'm making up the numbers now because I don't remember the numbers. And I'm going to say 50, and then you're going to say 67.5, and I'm going to say 53, and we're going to go back and forth, and we're going to get you where we both know you're going to be okay and I'm going to be okay. And we did that, and he thought it was nuts, but we got it done. So, sometimes you got to deal with those things. Note that there's no strictly identifiable pattern for any negotiation. It's just not the reality. Don't expect it to be. Expect the unexpected. It's just going to happen to you sometimes. The best advice I can give you is be prepared as much as you can reasonably be prepared. Think through all the possible... That's not true. Think through all reasonable iterations. I had a boss one time who used to say, well, we've got to be able to think through every possibility. And my answer was always, no, we have to think through reasonable possibilities. We never agreed, that boss and I, on that idea. We just sort of had to agree to disagree on that, because my attitude was you think through reasonable possibilities. You never think through every possibility, because frankly, you're not going to know every possibility anyway. Human beings are unpredictable. So you just never know exactly what they're going to do or say. Go through every reasonable probability and be prepared for it, and be prepared. If you don't know something, ask. And you will hear me say, and I've already said it, and I'll say it again, questions unasked are questions unanswered. If you need to know something, you better ask. Maybe the other side tells you, maybe they don't, but even when they don't tell you something, they are, in fact, telling you something, aren't they? They refuse to answer your question. And we'll talk about this idea of what do you do when the other side asks you something and you don't want to answer. How do you handle that? So we'll get to that later. What if your bargaining power is relatively different? What do you do then? Initially, and again, you're planning, we're just in the very beginning here. We're trying to figure out, well, what strategy? Am I going to be competitive? Am I going to be cooperative? Am I going to be problem solving? What are the avenues that I can use here to negotiate, and how am I planning? If you're in a weaker bargaining position, probably number one, you got to act tough. So you're going to have to build yourself up a little bit sometimes, and even though you know you have a weaker position, you're going to have to find a way to make it look like it's not. Probably one of the best things you can do is come in with confidence, and take every possible good, solid point that supports your view of the matter or your view of the case, as it were, and just hammer on that. A lot of times, I would deal with people and they would just kind of hammer on the one thing they had, and they talk about it all the time, and that's great, and it works to some extent. Eventually, it's going to fail you, but I mean, you got to use what you got to use, right? Shortly before I stopped practicing regularly, I had a case in which a fellow, my client, struck a pedestrian, but the pedestrian was very intoxicated, and she had a bad injury, unfortunately, and it was a very difficult case to get my hands around as to how to negotiate a resolution of it, because what do you do with that? I mean, she was drunk, and she was very drunk, and it was dark, and it was nighttime, and it wasn't. My client wasn't really going very fast, and the whole thing was a mess. And how do you settle that? We didn't settle it, unfortunately. It had to go to trial because I just couldn't get it resolved effectively. Partly because of, again, here's a good point: things outside my control affected the negotiation, and we couldn't get it settled. There were other insurance companies involved other than my insurance company, the one that I was working for, and we just couldn't get the thing resolved. Sometimes that happens, and I was in a weaker position because the injury was horrible, and even though the plaintiff was intoxicated, it never seemed to me completely clear that her intoxication was necessarily a cause of her injury. What do you do about ongoing relationships, and particularly ethical concerns about ongoing relationships? If you're an attorney, can you accept the idea that what you're negotiating is a good resolution, even though it's not the best resolution for your client, and you think, well, this is a good resolution for the system, so to speak. What do you do about that? Well, there is some sense that the norms of the bargaining community do kind of point towards a fair and just resolution. And what do I mean by that? Well, if the norms of your bargaining community, whatever they are, say that a certain kind of situation should result in, let's just take a personal injury case. Let's say it's a broken leg, and broken legs, I don't know, a broken leg goes for 50 grand. That's what, I'm just making this up. But let's just say that in your bargaining community, if you have a case where somebody gets a broken leg, they always get 50 grand. That's how much you get when you have a broken leg. Well, does that mean that if you're representing someone with a broken leg, you have to accept 50 grand? No. Does that mean if you're on the other side and you're going to be paying, you have to pay 50 grand? Well, no. But it does give you a sense of what seems to be the price, if you will. I mean, I hate to sound so, sort of cold and calculating about it, but that's what we do oftentimes in the law. The price of a broken leg is 50 grand. Well, then maybe that's a good result. And if you get 45, well, that's okay. If you get 55, that's okay. If you're somewhere around there. Now, if there are no other factors that suggest something different, then you kind of know you should be right around that number, right? And if that's where you end up, then everybody ought to kind of walk away reasonably satisfied. When there are other factors that come into play, then you might have a different issue, and then maybe it justifies the number going up or down depending, which way it should go. What about your client? How does that affect your strategies or your tactics, especially as you're orienting yourself? If you have a sophisticated client, you probably are going to have a lot of conversations with the client about what you're doing. Ironically, less sophisticated clients actually probably oftentimes get less face time with you and don't need as much face time because they kind of just want you to do what you do. And they kind of often will say, look, here's what I want. You just get me as close to that as you can and let me know when you get there. Whereas a sophisticated client oftentimes wants to be involved because they have a very high stake, and they're very interested in the circumstances. And some, not always if it's business deals, and I've seen situations with, business circumstances where the numbers were in the millions, and the negotiations were, the client was very involved in the negotiations. I mean, anything that happened, the attorney was back and forth with the client before even responding to the other attorney's statements or offers and so forth. So that's another thing you're going to have to keep in mind as you decide what you're going to do. As you're planning, what are some things you need to think about as you're planning? Well, you need to know the subject matter of the thing you're negotiating. You need to know it intimately and as well as you possibly can. You've got to work with your client. Obviously, your client has the last decision, rule 1, 2. Clients' issues aren't always money, could be ego issues at stake. Be careful if they're your ego issues or the other attorney's ego issues. You need to kind of ferret that out. Sometimes the attorney is really being obnoxious, not because the client wants the attorney to be obnoxious, but because the attorney is being obnoxious in order to prove something to someone. Maybe to you, maybe to the insurance company, maybe to a judge, maybe to his client, maybe to your client, who knows. You have to kind of see if you can't figure that out. And one of the ways you do is you ask questions about the circumstances so that you can determine, well, why does your client think that they deserve whatever it is the attorney's asking about? Ask why a lot. Why, be a 5-year-old. Why? Some of you, if you have small children, you know that feeling. Let me give you an example of a circumstance where you have to know what's going on and what your client's after and why certain things are the way they have to be. I was involved in a product liability case many years ago, representing the injured party. This person had a very serious injury. It was questionable or debatable whether the product itself did or didn't injure her, or whether she had some culpability. But her injuries were horrific. She insisted that we were not allowed to give the other side an initial demand. She wanted them to go first. She wanted the other side to make an offer first, and we explained to her, both myself and my boss, that that's not how it normally worked, that normally we were the ones who'd make the initial offer. She didn't like that idea, and she was very unsettled by the idea that we would cap ourselves off in effect. And we tried to explain to her, well, even if they make an initial offer, it's going to be so low that we're going to have to tell them something anyway. So it doesn't make any difference, but she insisted. And so I had to call the other attorney initially and make this sort of strange, we had to have this strange conversation about, hey, look, I can't give you a demand, but I need you to make an offer based on what you think my initial demand might be. And I had authority to make a counter demand once I got his initial demand. And so the other attorney, being a sophisticated guy, and he'd been around, and so he said, well, this is kind of particular and peculiar. And I said, I understand it is. You've met my client. You kind of have a sense of that. I really need you to do this for me, because if you don't, we're never going to get anywhere. We'll never get this case settled. I can't make you a demand. You're just going to have to give me an offer based on what you think my initial demand might be. And I have a number in mind that once you tell me your number, I can quickly give you a number. Um, and so it did work out. But how do you? It was just a strange way to do things. Well, we had to know that that's what our client wanted, and we had to deal with that. And we had to come up with an inventive way to get them to speak first. And we did. The case ultimately did get settled, so it did resolve itself. Those things happen. I'm going to, hopefully, you will have a brief movie clip from the movie Braveheart, in which Mel Gibson's character, I don't even remember his name now, Wallace, is negotiating with the Queen. And that's an instance where the other side hadn't done their homework, and they didn't really understand where this was coming, where this needed to go. And so you'll see that kind of can put it into some context if I'm able to do that. So hopefully you'll have that video clip available to you. If you don't, then I'll come up, and forgive me for not being able to get it to you. One of the other things you need to do as you're initially planning is that you've got to understand what your alternatives are. I think Gifford talks about the best alternative to a negotiated agreement. Basically, the idea is you have to have an understanding of what's going to happen if you don't get the deal done. What will your client do? What's the best thing that's going to happen? You will hear some people caution against a bottom line. My experience is people had quote-unquote bottom lines, and bottom line just meant that was their bottom line at the time. Everybody has a bottom line, and bottom lines change, and that's just terminology. It's just words. I think getting caught up in terminology is more of an academic exercise than a practical one. In my experience, calling something a bottom line doesn't mean that people are never going to change their mind. It just means that they have a basic idea of where they don't want to go below. It doesn't mean they won't go below. I've had people say, "Oh, our bottom line is $10,000," and next thing you know, the case settles for $7,500. Well, you just never. It's just one of those things. You just never say never, so to speak. So, but you need to know what's going to happen if you don't settle, and that's got to be part of your planning. Couple of final things to think about as you're planning. Use brainstorming when you can, if you can. If your client's willing, or if you have other lawyers that you can brainstorm with, or you have people you're accountable to or with, sit down and just throw out ideas. And I mean, I did this all the time with the other attorneys in my office. We did it a lot. I mean, I would go into the other attorney's office, and maybe 2 or 3 of us would sit down, or maybe we'd sit down in our conference room, and I'd just say, "What do you think about this mess that I'm in, this circumstance? What do you think about this? How about if I do this? How do you think that'll work? What do you think it'll work well? What if I went into a mediation one time, and I decided I was going to sort of act out of character. The other attorneys knew me. The judge, who was the mediator, knew me, and they knew that I was, generally speaking, kind of a calm, dispassionate sort of guy. I didn't usually get too emotional. In this instance, I decided to get in the face of the plaintiff. And my reasoning was that he had some drinking problems, and he was claiming that he'd somehow hurt his brain in a car accident, but there was some clear evidence that he'd had some problems with drinking in the past. And I pounded him, I mean, mercilessly in that mediation. And I looked him right in the eye, which was very unusual. I didn't normally talk to the plaintiff directly. I would normally just simply talk to the attorneys and the judge, and maybe casually talk to the plaintiff. In this instance, I tried to bore right through this guy and just tell him, "Look, you had drinking problems. It's going to come into evidence. I'm going to pound your doctor about it. I'm going to pound you about it in cross-examination. I'm going to hammer it over and over every chance I get. I'm going to bring up drinking. And I'm going to make you look like an alcoholic and a drunk, and I'm going to make you look so bad the jury's going to think you drank yourself into a stupor." Keep that in mind as you're talking about numbers. And was it a good strategy? I don't know. The case did get settled, and it did get resolved, and it got resolved at what I thought was a reasonable place. Did it work ultimately? Well, the case got settled. I don't know if my strategy worked or not. But we had to think about that, and I had sort of roundtabled that with the other attorneys in my office, and we all decided that it was probably the best way to go in this instance. And that's the point. I didn't do it on my own. I went in and talked to people and kind of thought about it. So think about those things. Last thing I'm going to talk about very briefly is leverage and power. And I know I'm running really long here, so forgive me, but I'm going to talk about these quickly. I had a couple of claims examiners who did things differently, and I reported as an attorney working with the insurance company. I reported to claims examiners to get the money in order to settle cases. And I had one particular claim examiner who always liked to wait till the last minute to get everything settled because he felt like the pressure was really on as the closer the trial got. In fact, oftentimes I would settle his cases literally either on the courthouse steps or really in the middle of trial. And his attitude was that when the pressure really got to people, that's when they really got to their true, this is what I'll really take. Was he right? I don't know. Sometimes I think he was, sometimes I think he wasn't. But that's one of the ways he used leverage. He would just put the pressure on the plaintiff. Because if you're a plaintiff and you're never sure whether you're going to get the money, and then you put the trial on, and then you have expenses, and suddenly it just doesn't look so good, and you feel this deep dread that, well, what if the jury doesn't give me anything, or what if they only give me this little bit of money? Whereas the insurance company usually has the money, so they can afford to go to trial and take their chances. What are some other things? There are friction costs to litigation, for instance. By that I mean there's expert fees that people have to pay, there are litigation fees or subpoena fees, and those kinds of things that you may or may not get back depending on your jurisdiction. And in business there are friction costs. There's things you have to do as a business person that you just simply have to do in order to make a deal work that you can't saddle the other side with and you don't get back as a result of the negotiation. So those things tend to cause pressure, and if the higher the friction cost, I'm just calling it that. You can call it whatever you want. The more pressure it puts on somebody. How about somebody's level of commitment? If they say we're taking this all the way to the Supreme Court, do you believe them? Well, maybe not. But if you think you can take them seriously, well, then that's something to take into consideration as you're planning. If you think there's somebody who's going to, maybe you think they're just nuts and they will take it to the Supreme Court, try to take it to the Supreme Court just because they're nutty, and you know they're nutty. Well, just based on past experience, well, that factors into your planning and your strategizing and what tactics and strategies you'll use, and how you're going to use that in your negotiation. Lastly, note this, that lawyers with more authority tend to do worse in negotiations than lawyers with less authority. Why that is not exactly clear. We could speculate all day. I'm not going to bore you with my speculation on that, but it's just a reality, and just know that going in. All right, what else? Sorry for that. Final thoughts. If you have higher aspirations, guess what? You tend to do better in a negotiation. Well, boy, is that surprising. If you're more confident, you do better. That shouldn't shock any of you. People who are more confident tend to do better generally in most things. So confidence level is important. And you should feel confident about your position. And if you don't feel confident, then maybe it's time to go back to your client and say, we got a real problem here, and here's the 5 problems we have, and you want to take those into account because I'm not feeling terrifically confident about our prospects here. So that's important for you to know as you're planning. Last thing, and this is very important for lawyers, understand that logic and rational thinking and rational analysis are very important in analyzing what you're going to do, but any negotiation is fraught with emotionally charged people. And despite what you think, even sophisticated business people get emotionally wound up about things, and people are people. And so you have to be on guard and aware of that reality, and that your simple logical and rational analysis, while very important, isn't enough. You got to be in touch with people. So you have to be ready to talk and understand people. And you got to kind of spend some time getting to know your client, especially in order to properly understand what your client's interests are and how you're going to get through your negotiation. All right, we're going to stop there. I do have a PowerPoint I want you to take a quick look at. It'll be much shorter than this.